A very good morning to all my dear students. So I hope in between these Diwali vacations and Diwali fun all over, you have been very sincere towards your studies because your exams are approaching and these are your revisionary sessions that you're doing. Good morning, Swati. Om Krishna. I'm the first one to join every time. Good morning, child. Good morning, Abhishek, Khushbu. Let me see all those who are with us on the admin portal also. So I hope you all have revised whatever you have done till now. I did share capital and debentures last with you, and after that, I hope you have revised your deposits, your dividend, and registration of charges as well. Just give me a moment. I'm just all right. Okay, a very good morning to everyone. So today we'll be doing a revision session for the chapter Management and Administration. So before we start with this session, let me just tell you that this is the longest chapter that you have for Companies Act. It includes lot of many things, number of forms, MGT 1, 2, 3, 4, so many forms. Then there is a beneficiary Ben forms also. And number of penalties will be coming up in this chapter MGT. So no matter it sounds very lengthy, but trust me, if you keep revising section wise, it is done. Okay, so just make small notes whenever we are revising, whenever we are discussing about provisions of small sections that you have in between the chapters. Sometimes you ask me, ma'am, is it mandatory? Yes, for CA Inter, definitely it is mandatory to have learning the sections and forms. But how does it become easy when you're doing it section wise? So if you open section 88 till 112, we'll be doing in this chapter, but we'll be breaking it into two sessions. One session I'm having with you, and then on 8th, I have another section. So today we will try to finish as far as possible. Let me just open the presentation for all of you. We'll try to, starting from section 88 till 105, I plan to finish off with you today. So I hope my PPT is visible to all of you. So this is your management and administration. So it is divided into different headings. So this is the whole breakup of this chapter. This chapter largely talks about meetings, how the meetings are conducted. You have understood by now how the shares have been taken up by the public, how the shareholders become the members of the company. The company has been accepting deposits. They have been getting registered, the charges, whatever they have secured. Now we are understanding how the company is functioning. Basically, what all meetings they are having, how the resolutions will be passed, what is all the compliance required to be done by the company is something which is very important, integral part of this whole chapter. All right. So registers is the first part that we'll be covering, and in between I will Khushbu is asking, can we draw pie diagrams in the exam? So you can draw charts and diagrams. References can be given in a form of flow chart, but please make sure that you write points in the exam. You cannot say that examiner asked me about register of members and I have just drawn the chart paper. That is not sufficient. You have to learn the written material. Yes, for revisions, for your preparations, you're making flow charts, you're learning, you're understanding, then it's fine. But there you have to write the content that has been asked to you. In short summary, if you're making small charts underneath, then it's fine. It is absolutely okay for that also. How many students have joined over here? I can only find few names on the admin portal. So those who are over there in the admin portal, they can send the query directly over there also. And those who are on the Zoom session, they can send their queries in the chat box as and when the session proceeds. So now we'll be beginning with the registers. So you all have heard the word register. What is a register? We are maintaining the data of all the members. So we start. So this chapter is divided into registers, annual returns. Then what are the pre-requirements of a meeting? Can you tell me what are the requirements of a meeting? When you do a meeting, you have to send a notice. You have to have invitations. You have to invite the shareholders. The quorum will be formed. What is the meaning of quorum? Since it's your revision, you know all these things, but we'll still be having each and every word will be revised in the session, but you should also answer me before we proceed further. What is the meaning of quorum? Can anyone tell me in the chat box? Quorum is the minimum number of members who shall be present at the time of the meeting. All right. So all these things, and then meetings, we'll be having AGM, EGM, annual general meeting, which is held annually every year, and then extraordinary general meeting is generally conducted. It is conducted to discuss about the special kind of businesses. So we'll be talking at length about what is the ordinary resolution, what is the special resolution, what is the ordinary business, how the business is conducted, every kind of things. And after passing the resolutions, we make the minutes of the meeting. Can anyone tell me another word group of members present? Very good, Swati. Correct answer given for the quorum. Can anyone tell me what is the meaning of minutes? You must have heard this word while studying for your English paper exam. Also, you have to make minutes of the meeting or minutes of certain discussion that you have. So what is the meaning of the word minutes? Absolutely correct. Minutes means a short summary that you have for the meeting, whatever has been discussed over there. Good morning, Mr. Arjun, Miss Vidya Shraddhe P. Minimum number required for meeting. That is absolutely correct. Miss Vidya, that's good. Okay. Summary of the meeting, Swati Om Krishnam, absolutely correct. So let's begin the session with Register of Members, Section 88. So now who are the members? The members are either the shareholders or the debenture holders or any other security. Now, very simple method. If you are a member, you're a shareholder, whether you're an equity or preference shareholder, you will be maintaining the register of members in the form of MGT1. And for debenture holders, we have MGT2, and for other security holders, MGT3. So in this presentation, I have just broken the forms. I've highlighted the things. So you just quickly have to flip the pages and you understand and learn. So every member's names will be recorded in the register of members. MGT1 is for the shareholders, equity and preference, debenture holders, MGT2, and other security holders, any other apart from debentures and equity and preference shares, MGT3 is used. Within how many days the entries have to be made? Within 7 days from the date of approval by the board. So board will see these are the members, and within the 7 days, entries have to be made in the register of members. After approving the allotment and transfer of shares, you have been allotted the shares, you have been given the debentures, and within 7 days after the approval of board or committee, after the approval, you will give the members entering the register of members. And once your name has been entered, means now you are the member of the company. You have taken the shares, you become shareholder. Once your name is entered in the register of members, you become the member of the company. Do we require to maintain the index in case of register of members? Answer me, hurry up. Do we need indexation? Yes, Miss Pooja, correct. Do we need index? Index is required if the number of members are more than 50. Very good. That's correct. So if your number of members is exactly 50, then do you need index? So index is not compulsory. It is required only if the number of members is 50 or more than 50. Even if it is exact 50, then yes, index has to be maintained. Registers have to be maintained at the RO of the company. What is the registered office? The registered office that you have studied in incorporation of company, you have studied at length about section 13, 14, 15, how the registered office is changed, how the registered office is maintained. It is talking about that registered office. There is where the registers have to be maintained. And if you want to maintain the register outside the place of the town and city, then what is required to be passed? SR or OR? What do we need to pass if we want to maintain the register of members outside the place? We have to pass a special resolution, and it shall be situated at a place where at least 1/10 of the total members of the company are residing. So if I am having a company which is having a registered office in Delhi, and if 1/10 of the members, 1,000 members are the total members, and if 1/10 of them, say 101 members are residing in Pune, can we keep the register of members in Pune? Yes or no? After passing SR, very good. Swati, Khushbu, Om Krishnam, absolutely correct answers you are giving. Rishabh Gupta, why you not answering? Yes, Pooja, correct answer. Vidya, Arjun, all of you have to answer. So yes, you can maintain if it is more than 1/10 of the number of members are residing, then you can maintain the registers there. So section 88 not just talks about the register of members in India, it also covers your foreign register. Now, what is foreign registers? I am having my place of business in Delhi, but I have such certain foreign shareholders also in my company. We have a place of office, say, in US also. So for US citizens, for those people who are my debenture holders and shareholders who are in outside the country, residing in that country, they can maintain a foreign register for entering the names of those members. But authorization is required in articles. So MCQ can come that can I maintain a foreign register if my articles does not authorize? Yes or no? Then the answer is no, because article of association should give you the permission. Then only you can keep a foreign register in any country outside India for entering the name of members who are residing in that country. So in that register, Mr. John, Mr. Paul, who are foreign residents, their name will be coming, not your Indian citizens' name will be coming. All the foreigners who are part of my company, we are having a place of business in US, their name will be entered in the foreign register. Within the 30 days of opening foreign register, company will have to file MGT3 form with RC. So MGT1, 2, you have understood. Here your MGT3 has come up for the foreign register. Company has to file MGT3 form with the ROC. In case you have decided to change the register or discontinue, again you have to intimate the ROC in MGT3 form. It says foreign register is part of company's register. So MCQ can come that how it has to be maintained. It has same rules and applications as they're applicable to the principal register. So my principal register is in RO office, that is Delhi. Now in foreign register, this is in US. So they have to be open for inspection and they can be closed. All the rules have to be same as applicable to the principal register. Can I inspect the foreign register? Yes, you can inspect the Indian register that has been kept in Pune, where 1/10 of members were residing, whether it is kept in Delhi. Similarly, you can inspect the foreign register, which is kept in US, provided the advertisement has to be given before closing the register. Inspection ke liye, it has to be open at least 2 hours for inspection. It has to be open during the working days. And whenever you're closing the register, at least 2 newspapers circulating in the place where the foreign register is kept, you have to give the ad in 2 newspapers. And both the newspapers in that foreign country in understandable in the language which is applicable in that particular foreign country. Now it talks about transmission of a copy of every entry. So every entry that you are making in the foreign register shall be transmitted to the RO also within 15 days. So whatever names Mr. John, Mr. Paul, Mr. Karan, whatever names you have entered in the foreign register, within 15 days you have to intimate the registered office also. And for the discontinuation, whenever you decide to discontinue, the company may discontinue keeping of any of the foreign register and all the entries shall be transferred to other foreign register kept outside India or the world. So now you have decided to close your US office. Now you're closing the foreign register. So any other place of business, you or the principal register, you can transmit those entries in that particular register. Now the penalty is something which will be coming in all the sections over here. You have been doing penalties till now also in the first module is finished by you. Now you're doing the second module of Companies Act. So the penalties you have learned over there, my humble request to all of you, whenever you read any penalty, just keep writing it down on a sheet of paper and just try to stick that paper on the front of the chapter. That is the only simplest way to learn the penalties by heart because you have no other choice rather than learning them. And if in case MCQs come to have happened, so the common penalty, which most of the cases you can strike is for the company, it is maximum 5 lakhs and the maximum 1 lakh and 447 fraud is also applicable if any kind of fraudulent thing has been done by the company, if you have not learned the exact penalty. And this is the kind of hints you can remember in order to trying to answer the correct answer. So if the company does not maintain register of members or debenture holders, or they have failed to comply with subsection 1 and 2 provisions of section 88, then 3 lakhs penalties and maximum penalty for every officer is 50,000. So here the short penalty has been given. It is not necessary that, why it is showing a hand raise? Okay. So it is not necessary that the same, it will never be the same penalty. It will be different penalties for every sections. So you just have to remember that the penalty for section 88 default is 3 lakh rupees maximum for the penalty for the company, and any officer who is in default is maximum penalty of 50,000 rupees. Okay. Now moving to section 89, declaration in respect of beneficial interest in any share. So what is the meaning of beneficial interest? What do you understand by the word beneficial interest? Quickly answer me, children. You have to answer me this one. What is the meaning of beneficial interest? Can any shareholder, but before we proceed further, let me just ask you 2 questions. Can minor's name be entered in the register of members? We have just done register and foreign registers. I have 2 questions for you. Can a minor's name be entered in the register of members? Yes or no? Or only the legal guardian's name will be entered? Only the Legal guardian's name has to be entered. Absolutely correct. All those who have given the correct answer, that is absolutely correct. Okay, dividend and voting right, that's nice. So, debenture holders, and in case of the joint shareholders, how the names have to be entered in the sequence of their seniority. Whose name is appearing in the first in the register of members, they will be considered as the person who is having a seniority in respect of the joint members. Now, let's move to the beneficial owner declaration in respect of the beneficial interest in any shares. Now, if the members are not holding beneficial interest or the person is holding beneficiary interest, any change in the beneficial interest of person, all these kind of things, a declaration has to be made to the company within 30 days, and company shall file with a return in MGT 6 with ROC in 30 days. Now, how we have to learn this is sometimes there is a name of the person who is entered in the register of members, but the beneficial owner is somebody else. Beneficial owner means the person who is having the beneficial interest. I am the shareholder of the company, but my benefits and the rights have been assigned to somebody else. So that person becomes the beneficial person. Beneficial person means whose name has been, my name has been entered, the name has been entered, but the beneficial owner is someone else. Then in that case, the person who has assigned, who has made the beneficial interest to someone else, and that person within 30 days have to inform the company that please enter my name and register of members in MGT 4 form and make a declaration specifying the names and the particulars of the person who is the beneficial owner. And the person who has acquired this beneficial interest also has to make a declaration in MGT 5 and has to file it within 30 days with the company that I am the person who has the beneficial interest in the respect of these are the shares which are registered and this is the beneficial interest that I'm holding in the company. And after that, the company needs to make a declaration. The company will note down these declarations and will file within 30 days a return in MGT 6 with the registrar along with the fees which is prescribed over there. Any change which happens in the registered, in the beneficial owner's interest, that also has to be intimated to the ROC within 30 days of such change. What will happen if no declaration has been made by the beneficial owner? If the company fails to file it with the registrar or no person has informed that this is the beneficial owner, then what will happen? You have to answer me. This is your revision. I will not be telling you each and everything. So declaration has to be made. If no declaration has been made, then what will happen? Yes, there will be a penalty, no doubt in that, but no right will be given to the person claiming that beneficial interest. Please write down in your notes if you don't know, penalty will definitely come up, but please write down where no declaration has been made as required under the section, where no declaration has been made by the beneficial owner, then no rights shall be claimed by him under this respective section of beneficial interest. So law will say that if you want to be a beneficial owner, you have to file MGT 5, else you cannot claim the rights in the company for your future. You will not have any of the rights. And what is the penalty that a company will give dividend to whom? Duty of the company to pay dividend will not be affected. Who will be getting the dividend? Members or the beneficial owner? Answer me. Who will get the benefits? Who will get the dividend? Beneficial owner or the members? The members will be getting the dividend, not the beneficial owner. And if any default has been made, penalty of 50,000 rupees and for rupees 200 for every day during which the default continues. And I told you maximum penalties, most of the cases is 5 lakh. And for the officer in default, 1,000 for each day, maximum again of rupees 5 lakhs in case the officer in default continues to make this penalty. I think it is 2 lakh rupees for the officer in default. All right. Good. Yes, the members will get. Good, Swati and Khushbu. Members will be getting the dividend, not the beneficial owner. Now, moving about the registered of the beneficial owner of the company. What is Section 90? Section 89 tells you that declaration has to be maintained in MGT 4, 5, and the company will be filing a return in MGT 6, that these are the people who are the beneficial owner of the company. Name of the person has been entered in the register of members, but there is somebody else who is the beneficial owner. Then those people under Section 89, subsection 1, 2, 3 have to make a declaration. No declaration has been made, no right will be given, and then there is a penalty that we just did. But what is Section 90 talking about? Section 90 talks about significant beneficial owner. Who is a significant beneficial owner? First, we have to understand the definition of a significant beneficial owner. Then we will understand how they have to file the beneficiary forms. So whenever examiner is talking about section 90, significant beneficial owner, then from MGT forms, we change to BEN forms. So BEN 1, BEN 2, BEN 3 will be coming. That is beneficial owner. So beneficial owner ka BEN forms hai. MGT means management and administration. Every chapter along with its names, abbreviations, the forms have been used. So it becomes easy to learn when you learn the forms along with every sections. So beneficial owner is an individual who alone or together or through one or more persons of trust acquire these one or more of the following rights. What are the rights that he has acquired? He is holding not less than 10% of the shares of the company. So if I'm holding more than 10% of the shares of the company, I become a significant beneficial owner. If I'm holding more than 10% of the voting rights in the shares of the company, then also I become a beneficial owner. Either one or more. Agar ek right hai, then also I become a significant beneficial owner. More of than one, then also become a significant beneficial. If I have more than 10% of the distributable dividend rights in the dividends is more than 10%, rights in the shares is more than 10%, or right in the voting powers is more than 10%, holding directly or indirectly together with another direct holding more than 10% of the dividend rights, or the person has the right to exercise significant influence through any other than the direct holdings alone. He is exercising significant influence also. Any of these conditions are met, then he becomes the significant beneficial owner. Now, what are the rights of the significant beneficial owner? Let me just take you to the study material because there is huge content given over there. So I don't want you to miss upon any of the content of the study also. So I told you section 88 to 122 are part of this chapter, and around till 105 or 104 we'll try to finish. So now we are in the part of registers is the first part that we'll be finishing in this class today. Section 88, 91, 95, all it talks about the registers. And then section 92 to 94 is broadly going to talk about your annual meetings, annual returns, and meetings starts from section 96. Section 96 will tell you about 97, 98 is your tribunal holding the meetings, and AGM has to be held. 100 section is very important, which tells you about the EGM. And then 101, 102. Till here we'll be doing, and all the requirements of convening a meeting from 103 to 120 we'll be covering in the second session. So this is how you see how beautifully study material has made all these notes for you. Such a nice breakup. I know, at times I feel you students are really so blessed. All the work has been done by institute itself for all of you. You don't even have to think about how the charts have to be made, how the summaries have to be made. They have so nicely had made such brief, beautiful summaries for you. So it is such a quick revision. Rules 3, okay, even if you don't remember rules, it's okay. MGD 1, 2, it is clearly written over here. Maintenance of registers, rule 5, index has to be maintained or not. You have learned it. Whether it is more than 50 members, then index is required. So foreign registers, they have specifically told you MGD 3 is the foreign register. MGT 4, 5, 6 kiska tha? We just did a declaration of the beneficial interest. Now we are running through the significant beneficial owner from the study material. So again, you don't have to make small notes from these points that I've told you in the summary in my notes. You can refer it to from there also. So these are all the points that we have done for foreign registers. We have done their penalties also. So again, these illustrations, children, please, since it's a revision, I cannot do all the illustrations and question answers with you, but please try reading all the illustrations that are given over here. Okay, minors are not competent. We have covered this point also. So you have understood how the joint shareholders have to be taken care of. Though illustration 1 or 2 exactly on the same points that I've just made you note down in the points. How the joint shareholders' names will appear and how the minors' name will appear. All these points is talking about. All right, now quickly let's go to the significant beneficial owner. Exemption has been given to government companies. Do read that as well. So significant beneficial owners, it says MC has issued the company's rules. Specific rules have been given for the significant beneficial rules along with the identification and connection of the significant beneficial owner. So ma'am, kya learn karna hai isme? We have to learn the definition. This whole page is broken up into my first slide that I have told you. This is the definition that you have to learn. More than 10% of the share capital, more than 10% of the voting power, more than 10% of the distributed dividend right, or exercising significant events, then you become the significant beneficial owner. Now, what is the major stake? So again, majority stake means more than one half of the equity shares or more than one half of the voting power. But directly and indirectly holding, you can refer to this, how you're holding it directly. Indirectly means you're holding through a body corporate or Hindu undivided family. Now, owners on the reporting company, it is on the reporting company to identify whether you have a significant beneficial owner, and that person has to make a declaration. Now, what will happen when I was the beneficial owner? I was supposed to make a declaration in MGT 4, MGT 5, MGT 6, we have understood in section 89. Now, again, under section 90 tells you that the person who has become the significant beneficial owner and he has come to the knowledge that he is the significant beneficial owner, he has to make a declaration to company that yes, in Ben 1, I am making a declaration, I am the beneficial owner of the company. You can write down these points, but say you can write down every significant beneficial owner has to make a declaration in Ben 1 within 30 days of becoming the significant beneficial owner. So Ben 1 has to be used within 30 days of becoming the significant beneficial owner. He has to make a declaration. This declaration is always in the form Ben 1. Then what will happen? Company will maintain a register in the form of Ben 3. This is what is mentioning about the companies maintaining a register. Company will maintain the register in the point number Ben 3, that about the details about whosoever is the significant beneficial owner in my company. This register shall be kept open for inspection. Anyone can come and inspect it. This is your point for inspection. So point number 1, you have made down Ben 1 within 30 days of becoming SBO. Point number 2, you have marked in your study material only. Ben 3 has to be maintained by the company. It shall be open for inspection. Point number 3, inspection can be done by any person. And how the inspection has to be done? During the working hours, minimum 2 hours has to be given on any working day on the payment of fee. Same that you have done a register of members inspection, same way significant beneficial owner and trust can also be inspected. Now, what will happen about the application of tribunal? Say, for example, the company person fails to give the company in Ben 4, they have not provided the information within 30 days. I told you that you have to inform. Here it is written. It says that you have to inform the company. Company shall give a notice of Ben 4 to any person, whether he's a member or not, to whom the company believes that he is a significant beneficiary. Say, for example, significant beneficial owner fails to give Ben 1. They have not submitted Ben 1. Now, company wants to find out who is this significant beneficial owner. So, if company believes that you are the significant beneficial owner, or they have the knowledge, or you have been the significant beneficial owner from 3 immediately preceding years, then company will send you a notice in Ben 4. That please confirm us that yes, you are the person and who is not registered with the SBO. Okay? Who is not registered as the significant beneficial owner with the company required. So if you have not registered, you have not filed Ben 1, then company will send you a notice in Ben 4 that please confirm us that you are the significant beneficial owner of the company. What will happen then? Now, if the company has given you, if the person fails to give the company information required, I have already sent you Ben 4, you have failed to give me the information, you have not reverted within 30 days of receiving, or the information that you have given is not satisfactory, then company will go to the tribunal within 15 days of the expiry of this time. So company has sent a notice in Ben 4 and he fails to get the reply within 30 days, then within a period of 15 days, company will go to the tribunal. So you will remember the company person fails to give the information within the time prescribed, that is within 30 days he has to reply, but then within 15 days of the expiry of the time that has been given, company can go to the tribunal. Tribunal will then try to pass the order passing the restricting of the rights. He will say that significant beneficial owner, say you were the beneficial owner, you have not intimated to the company sent you Ben 4, still you have not replied. Now your rights to those shares will be restricted. And within till 1 year, this restriction will remain. You cannot remove it. So within 1 year, The significant beneficial owner, if gives the information, then this restriction can be removed. Otherwise, it remains restriction. And if no application has been made, see, this is your order of tribunal will be subject to the restrictions included. Tribunal will pass the order restricting the share of transfer, suspend his rights, suspend his voting rights, or any other restrictions can be provided with respect to the shares which were held by him. And now this restrictions will remain for 60 days of the receipt of the applications. How many days the person has been a time period to make the application? Within 60 days on receiving the application, the parties can make an application or appeal to the tribunal. Company or the aggrieved person can make an application and take the relaxation within a period of 1 year. So within 1 year, if you have come and made the application and tribunal is satisfied, he will remove the application of the restriction. But if you have not filed this application within a period of 1 year, then where does the amount get transferred? Please tell me. You have to answer me. This is your revision. You're listening as if you're listening to the first time. Are you attending the session for the first time? You have learned it. Tell me fatapat se, where will the amount get transferred? The company will transfer all the amount without any restrictions. The amount will be get transferred to which fund? Investor Education and Protection Fund. IEPF authority will come and take these restrictions. All the application, if within 1 year application has not been made of the restrictions that have been made, then all the amount of significant beneficial interest will be transferred to the IEPF account. Ritu and Om Krishna were the first one to answer. Great. Well done. Is that fine? So declarations have to be given. Now, this is the point which I made you write down as point number 1. So it might have ups and downs over here written, but what is important is that you have to learn it in the same format. So within Ben 1, you have to give the declaration. Ben 2 is the company to make an application with the registrar. Individual who is the beneficial owner and fails to give shall give a declaration in the form of Ben 1 within 30 days of any changes which is happening. And then Ben 4, you have understood, company is giving Ben 4. If he fails to give the application, tribunal, he will go to the tribunal. Tribunal will pass the order for the restrictions. Within 1 year, you can make an application for removal of such restrictions. And if no application has been made, the entire amount lying for the significant beneficial owner will go to the Investor Education and Protection Fund. Is that clear? Again, penalty. So all this chapter is about understanding the provisions, then penalty. Understanding the provisions, then penalty. So how much penalty? 50,000 rupees, 1,000 for every day during which the default continues and subject to maximum of 2 lakh rupees. By reporting company, again 25,000 for any default which is continued, maximum penalty of 1 lakh rupees. So again, section 89, penalties. I don't know why this hand raise is coming again and again. All right. So section 89, penalties by the company, by officer in default. Section 88, penalties. Section 90, penalties. Keep making a note on a separate sheet of paper and stick it on the above first page of the chapter so that on the exam day, you can just read the penalties from here. You don't have to go to each section to find out what is the penalties. Is that clear? So we have done 3 important sections, that is section 88, 89, and as well section 90. Now let's move to the significant beneficial owner is also done. Now let's move to the annual return, section 92. Are we missing upon any of the section? Let me just find it out. Section 91, power to close register of members. Okay, let us do this also, power to close the registers, because it is also a very important section. Section 91. So can we close the register of members or debenture holders? Section 91 says who has the power to close these register of members. We have understood section 88, register of members, register of debenture holders. Jaise members ka hai, waise debenture holders. So if examiner asks you what is the provision applicable to the register of debenture holders, again section 88 that you have understood for the register of members. Okay, but the only difference is MGT 1 for register of members, equity and preference, MGT 2 for debenture holders. Any other security holders, MGT 3. How you can close it? Section 91 deals with the time limits for closing of the register. It tells you what are the time limits and what penalty will be applicable for closure. Now, please listen very, very carefully. Section 91 is very important. It is little tricky, but if you listen carefully, then it becomes very easy. A company may close its register of members or the debenture holders registers for a period of 45 days in each financial year. So in every financial year, if you want, may ka matlab hota hai choice. Interpretation of statutes, you will be understand. There is a difference between the word may, must and shall. May means you have a choice. It is not compulsory. company may close its register of members. For how many days it can close it? It can close for maximum of 45 days. And when it decided to close its register, then it shall continuously close it for 30 days at any time. So if on 5th August, I had decided to close my register, I can close the register for a period of 45 days. But for how many days it will continue? 5th August till 5th September, for 30 days time period, I can continuously close my register of members. 7 days notice has to be given, or the time prescribed by SEBI for the listed companies whenever you want to close the register of members or debenture holders or any security holders. What is the time period for giving the notice? Please tell me. Is it 30 days, 45 days, or 7 days? What is the time period for giving the notice? Yes, good. Optional. May means optional, not mandatory. That's good. So what is the time period? 7 days. What time period has been given? So within 7 days, a previous notice has to be given for at least 7 days, or the time may be specified by SEBI. Very good. Khushbu, Ritu, correct. So minimum 7 days notice has to be given if you want to close the register of members. Again, the company closing the register of members in 2 vernacular newspapers, at least one in vernacular newspaper means the newspaper of your local language where your principal place of business is located, and once in English language newspaper, you have to give the circulation. This is how the notice has to be given for closing the register of members. The same way I told you a foreign register, when you were closing the register, you have to give the newspaper ads in 2 newspapers that we are closing the registers. And here, if you're closing the register of members or debenture holders under section 88 wala jo aap register close kar rahe ho, to them section 91 is applicable, that if you're closing, you have to give the advertisement in at least once in vernacular newspaper and another in English newspaper. Exemption to private companies. Private companies has been exempted from issuing the public notice in newspaper provided it issues 7 days notice. So private company has given a 7 days notice, and it's absolutely fine. You don't have to give any public notice. You don't have to give the notice in the, an examiner can give you this MCQ. There was a private company. It gave the 7-day notice to its members for closing the register, but it failed to give a public notice. Is there any problem? Is the company has done something wrong or right? Penalty will be applicable, yes or no? Answer me. Private company failed to give. Khushbu, which point you want me to explain, beta? Please ask. Which point are you asking? Yemen is the first one to give the correct answer. Kiran Mishra. Okay, fine. Now you have started answering. Very good, Om Prakash, Ritu. Very good. So listen very carefully. Somebody was asking. Yes, who was asking? Khushbu was asking those points again. So I'll tell you, whenever you are closing the register of members, you have to give your advertisement in 2 newspapers, one in vernacular newspaper. Vernacular newspaper means if you are in Maharashtra, Marathi newspaper that comes over there in the same language, you have to give ad in that newspaper, and one in English newspaper so that everybody who knows English can read that now the register of members is being closed, and also on the website as may be notified by the central government. So any website of the company, you can also publish the notice on the website. But in case of private company, you can only give the 7 days prior notice to the members that we are closing the registers. There is no need to give any public notice in the newspapers. Okay, very good. So penalties in case of contravention, if shorter notice has been given for a continuous aggregate period, then every officer, it says, if the respective registers are closed without giving public notice, you have not given the public notice, you failed to give the public notice, or you have, after giving a shorter notice, means 7 days ka notice dena zaruri tha, aapne nahi di. Minimum 7 days ka notice nahi diya, you have given a shorter notice, then, or for a continuous of aggregate, continuously for an aggregate period in excess of the limit. So I told you can close it for continuously for 30 days or maximum of 45 days. You have closed it for more than that, then whatever penalty will be 5,000 per day, subject to maximum 1 lakh for which the register has been kept closed. It is a compoundable offense under 441. When you read 441, there you will understand what is 441. As of now, simply you have to remember it is a compoundable offense. There are certain offenses which are compoundable, certain which are not compoundable. Compoundable means they can be compromised in exchange of any other thing. All right. Is that clear, children? I hope section 91 is absolutely clear. It's important from the viewpoint of MCQs. It is important. Good. Om Krishna. I'm glad you're enjoying these sessions. When you send such thumbs up means you're absolutely clear. Why my screen is showing a hand raise, I really fail to understand. Why it is showing a hand raise again. I don't know why it is happening. Yes. Good, Ritu and Swati, everyone. Now we are going to understand what is the meaning of annual return. So you made your company, you have filed your financial statements, everything has been done. You have understood about these provisions of shares and debentures and whatever you have taken in the company. Now you have to file an annual return with the company. Remember, in all the previous chapters, Section 92 provision was being referred. If the company has filed its annual return, then these kind of exemptions will be given. Today is the day when you'll understand what is this actually annual return. So every company will prepare a return in the prescribed form for the close of the financial year. So when you're closing the financial year, you will prepare a proper annual return. All these are the contents of the annual return. In the annual return, you will tell this is my registered office. This is the principal business activities that I do. Okay, these are my business activities. I'm to say, for example, sale and purchase of cloth. So this is the business that I do. These are the particulars of these are my holding and subsidiary companies. So first point relates to your office, your business activities, and your holding and subsidiary relationship. Second point relates to your shares, debentures, and shareholding pattern. How many shareholders are there? Okay, Abhishek Singh, thank you so much. This is AI what is doing all these kind of things. That's nice. Thank you, Abhishek. I liked your explanation of hand raise. So he says that when I do like that, so AI tools is capturing the hand raise over there. All right. Close period and notice period. Kushbu, I hope now you're clear with the closing period and the notice period. Notice period means you have to send 7 days notice to the members that we are closing the register of members. Okay. So I have sent you 7 days notice that, madam, I'm closing the register of members, and now I will close the register of members for 45 days. I can, but wherever I choose to close the period for 30 days continuously, it has to remain closed. Okay. One is the notice, one is the period for which it has been closed. Okay. So every company has to file the annual return at the end of the close of financial year. That is for the registered office, principal base of business activities, and the holding and subsidiary relationship. Then all the shares and debentures that I'm holding, its indebtedness means to whom it has to pay back the money. The members and debenture holders along with any changes. So who are my members, who are my debenture holders, any changes in their members and debenture holders, all these kind of things. Who are the promoters, directors, and key managerial personnel since the previous financial year. How the meetings have been held, how my meetings of members and board meetings have been held, what is the remuneration that I'm paying to. So you can make small abbreviations in order to learn these kind of contents, although it is not very important. But since we are doing each and every section, so section 92 tells you, first topic, it tells you what are the contents, or these are the details of the annual. What penalties have been imposed on the directors, what are the matters related to the compliance and disclosures, the foreign institutional investors holding the shares in my company, all these details. So even if you may remember 3 to 4 of them, that is also fine if the examiner gives you a straightforward question or note on the annual return. Yeah, that's absolutely correct, Khushbu, that you've written over there. So annual return is basically the return that you're giving about all the details that you have done in your business. Now, central government has prescribed an abridged form of annual return for one-person company or such other class of companies. So for one-person company and another class of companies, MGT 7A form has to be used. What is the form for one-person company? Now, again, this is very important. This is a very different kind of question examiner can choose to give you in your MCQs. So what is the form number? MGT 7A is the form that you have to learn for OPC, and for small companies, it is MGT 7A. What is the form for other companies? Please tell me. For OPC and small companies, it is MGT 7A that has to be used for the annual return. What is the form for other companies? I've not written it over here. Find it out and tell me. Is it MGT 6, it is MGT 7, or it is MGT 8? I've given you choices also. For other companies, it is MGT 7. Very good, Abhishek Singh. Swati, wrong. It is not MGT 8. MGT 8 is for something else. It is for the certificates that you're taking for the certificate that you're taking for the compliance and disclosure. That is for MGT 8. So annual return has to be very good. MGT 7. Good, good. All of you have answered correctly. Ritu, that's correct. So now who will sign the annual return? Please tell me. In case of OPC and small company, the return has to be signed by the company secretary. And if there is no company secretary, then by the director of the company. In all other cases, by a director and company secretary, both shall sign. So annual return has to be signed. You can make a short note. Annual return has to be signed by CS as well as director. But if it is an OPC, then who will sign my annual return? Answer me. In case of OPC, who will sign the annual return? Who will sign the annual return in case of OPC? Buyer, say company secretary, and if there is no company secretary, then buyer director. All those who are giving you, why giving me a choice, director or CS? You have to remember in case of OPC and small companies by CS. Swati is correct. Others have written wrong. By director, you are writing director is wrong answer. You will write by company secretary. See, I've written over here. In 1% company and small company, return will be signed by company secretary. Or if there is no company secretary, then it shall be signed by the director of the company. So any other company, director plus CS both, OPC and small company, CS. If no CS, then by director. ठीक है. Form AR, form of annual return, MGT 7A for small and 1% companies, and other companies, MGT 7. Certification has to be given. It says annual return has to be filed by the listed companies who will certify. Certify means you have to, CS in practice will certify that all the disclosure and compliance have been made, properly done, all the facts have been correctly disclosed. Which is why it is required for those companies which have the paid up share capital of more than 10 crores or the turnover of more than 50 crores. Then a CS in practice will state that the annual return is disclosing all the matters correctly in form MGT 8. A certificate of company secretary is required. And every company will place this annual returns copies on the website, and the web link shall also be disclosed in the board's report. You will give the link of the websites in the board's report that anyone who wants to view, they can see how the annual returns have been maintained, what are all the details of the shareholder, debentures, promoters, remuneration, kitni dete hain unko, penalties kya hai. All these matters are shared in the annual return. They will also be placed in the website, and the web link will be given in the board's report. Now, annual return has to be filed by number one by listed companies and the companies having a paid up share capital more than 10 crores and turnover more than 50 crores. And what is additionally required? It has to be certified by a CS in practice. In which form the CS will give the certification that all the disclosure and compliance has been done? Is it MGT 9, MGT 8 or MGT 7? Hurry up, tell me. Company has complied with all the provisions and had disclosed everything. A CS in practice will give this. In MGT what? Very good. Abhishek, Om, Krishnam, Kushbu, Swati, all of you correct. MGT 8. Kushbu, MGT 8. Okay, that's correct. MGT 8, you have to give that. This is the point that this line I've underlined above point number 5. MGT 8 form has to be given that all the compliance has been done properly. Try to learn it when we are doing it side by side so that you don't have to again and again open the books and find it out. Every company will file with the registrar a copy within 60 days from the date on which the AGM held. Now, so far we have been doing the provisions of 30 days. Okay, and now another tip for learning the thing. How will we learn, ma'am? Abhi tak section 91, everything was till 30 days. You have to file with ROC. The 30 days, the company significant owner was also coming within 30 days. Only the tribunal thing that we did, there were difference of the number of days. And now here, annual return has to be filed within 60 days on the date on which the annual general meeting is held. And if no annual general meeting has been held, then within 60 days from the day on which the AGM was to be held, specifying also the reasons why the AGM has not been held. So every company has to file a copy of annual return with the ROC also. Within how many days you have to file the copy with the ROC? Miss Pooja, Unikrishnan, Miss Jayashree, Vidyashree, all of you giving correct answers over here. Vidya, Shradhe, Jayashree, all of you have given the correct answers, beta. Nice. Okay. So ROC, you have to file within 60 days. Very good, very good, very good. All of you have given the correct answer. For 60 days also, for MGT 8 also, everybody has given the correct answer. And what is the penalty if you fail to file the annual return within the time prescribed? Then the penalty for every officer in default shall be maximum 2,000 for every day during which the default continues. No, maximum penalty is 10,000 rupees. 10,000 and 100 for each day during which the default continues, subject to maximum of 2 lakh rupees and 50,000 in case of officer in default. If company secretary who's in practices certifies the annual return, otherwise then, what is the meaning of otherwise means? Company secretary had to comply that all the disclosure has been made, all the compliance has been done, but it does not, it fails to tell you if the annual return was not correctly prepared and it still signed it, then he shall be liable to penalty of 2 lakh rupees. So CS has to be very careful in analyzing the annual return and giving the certification that all the disclosure and compliance has been done. They have to be very careful. They have to form a set pattern of seeing all the disclosure has been done. Otherwise, a penalty of 2 lakh rupees will be fined for the CS also. Okay. Section 94. Section 94 tells you about till here. Any doubts till section 92, children? I hope there is no doubt till section 92. Place of keeping and inspection of the register of members. So the registers have to be kept and maintained under section 88. Section 88 talks about the register of members. Good. Om Krishnam says everything is clear. Very good. So section 88 talks about the register of members and the copies of annual return. Annual return, section 92 talks about the annual return. All these copies have to be kept at the RO of the company, that is register office of the company. But you can take it at any other place. I told you then what needs to be passed? SR needs to be passed, and more than 1/10 of the total number of members shall be residing. We just did it when we started the chapter, that can you take the register of members outside? When we were in Delhi, we took it in Pune because more than 1/10 of the members were residing. So if there are 1,000 members, if 101 members are residing in Pune, you can take it provided SR needs to be passed. Registers and other indexes, except when they're closed, and copy of the returns shall be open for inspection. So you shall keep all these copies open for inspection. Any of the shareholder can come and inspect these. Any of the shareholder, any of the debenture holder. So if I ask you, can the company's debenture holders inspect the register of members? Yes or no? And for how long they can inspect it on any working day? Can the company's debenture holders or any other security holders inspect the registers? Yes, they can inspect. Very good. That's correct. Very good. They can inspect for how many hours? I asked you. And during business hours, that is absolutely correct. All of you are correctly answering. But for how many hours? At least 2 hours. Yeah, I mean, very good. At least 2 hours have to be given them on any working day that you can come and do the inspection. The reasonable time of not less than 2 hours will be given without any payment of fees. Do you need to pay any fees? You are the debenture holder. Your name has been entered. You can come and inspect it at any time during the business. Following particulars of the except when closed means when you have closed it, then you have already intimated them by sending section 91 notice of 7 days, then it is a separate story. And they can also ask for the extracts from the copies of the registers. Following particulars of the register in respect of the return of the members of the company shall not be available for inspection for taking extracts unless the name, address, or unique identification number and PAN number has been given. All right. The following particulars, it says that shall not be made available for the inspection. All these kind of details cannot be given for the inspection when you're allowing the inspection of the register of members. Any member, debenture holder, security holder, or even the beneficial owner can take the extracts from the registers, and they can, if they have asked for the extracts, within how many days the extracts have to be supplied? Within 7 days. So any member went to the company and they said that we want to take certain extracts from the register of the members, then within how many days the company has to give the extracts? Within 7 days of the receipt of fees, they have to give the extracts from the registers. Is that clear? So first part of section 94 talks about the registers that have to be maintained. They will be at the RO office, and if any SR has been passed or when more than 1/10 of the members are residing, you can take the register out from there. Then it talked about inspection time period that has been given to you. Maximum time period 2 hours can be given during any business day. And then can you ask for the extracts? Yes, you can ask for the extracts, and any extracts that you have asked has to be supplied within 7 days of the deposit of. Now we are going to talk about the period for which these registers, returns, and records. Registers, returns, and records means section 88 registers, foreign registers. Returns means annual returns, section 91. All these registers and records have to be kept for how long time period? So it says register of members along with section 88 index shall be preserved permanently in the custody of company secretary. So number one point is where it has to be preserved, and number two is within whose custody. So you can break it down in points. Number one, it has to be preserved permanently. ROM, that is register of members, have to be preserved permanently. And whose custody, who will keep it? The CS of the company or any other person authorized. So company secretary will keep all these registers. Register of debenture holders and any of the securities holders shall be kept for 8 years from the date of redemption of the shares or debentures, as the case may be, and will be kept. So if I have redeemed the debentures, so for after redemption also at least 8 years for period they have to be maintained. So permanently you have to reserve the register of members, but the debentures which have been redeemed, at least after redemption also for at least 8 years they have to be maintained, and again they will be kept in the custody of company secretary. Annual returns which have been prepared in Section 92 and all the certificates and documents required shall be preserved for a period of 8 years from the date of filing with the ROC. Again, they will also be in the custody of your, they will have from the 8 years from the date of, so you have filed your annual return with the ROC, then after that, 8 years it has to be maintained. So any foreign registers, any register of members, any debenture holders registers, all of them have to be maintained permanently unless they have been discontinued. So 8 years after the redemption of debentures and security holders and other registers under Section 88 has to be maintained permanently. Annual return has to be preserved for how many years? Tell me, children. Annual returns prepared under Section 92 have to be preserved permanently or for how many years? Answer me quickly. They have to be preserved for 7 years, 5 years, 8 years, or permanently. Very good. 8 years is the correct answer. Annual return, 8 years. Om Krishna, why did you say permanently? So permanently was for the register of members. Om Sagar could, Swati could, Ritu could. So for annual return, so that means you're not here carefully, okay? All right, that's fine. So annual return का 8 years है, redemption of debentures के बाद 8 years है, register of members का permanent. Foreign registers also permanently unless it is discontinued or it is transferred. Remember when we discussed foreign registers, they are either discontinued or transferred to any other register, then they are not maintained. Otherwise, they're also maintained permanently. Foreign register of debenture holders also 8 years from the redemption of debenture holders. Same provisions from the principal register we have understood. Similarly, foreign registers also have to be maintained. And they shall also be kept in the custody of company secretary or any other person authorized by the board. If any inspection or making any extracts has been refused, now you say that, okay, fine, any member came and he said, I want to inspect the books of accounts or I want to inspect the register of members, and the officer refuses it. Then the company and every officer who is in default, a penalty of 1,000 for every day subject to maximum of 1 lakh, during which the default continues. Central government by order direct immediate inspection of the books and direct these extracts to be taken by the person requiring it. CG can also intervene over here. CG can pass orders, immediate inspection of the documents and extract, because you're running a company, you cannot hide anything from the debenture holders and shareholders. You have entered their name. Why you're not showing them the inspection? Why you're not allowing inspection? Why you have not given the extract within 7 days of the receipt of the fees? So now central government can also intervene. Central government has the power. They can pass an order that immediate inspection of the documents can be done, and also the exact extracts can be taken, shall be allowed to be taken by the person required. All right, now my last question before I go to the break for this part of the session. We have finished the registers, everything has been done. We'll be starting with the general meetings now. But my question to all of you is, I just taught you the following particulars of the register or index shall not be made available for inspection. What are the things which shall not be made available for inspection? Quickly tell me. I give you a hint. In case of body corporate, it is the registered address. Address or the registered following particulars of register shall not be made available for inspection. Next is email IDs and unique identification number and PAN numbers. Where it is written, ma'am, here it is written. So I just showed you over here. So this small paragraph after point number 2, please mark it out. Following particulars, the last paragraph, following particulars shall not be available for inspection in case of company, registered address, and email IDs, unique identification number and PAN number shall not be available for inspection. UID and PAN numbers, very good, very good. Very good. All of you have given the correct answers. So here we'll take a small break, children. Just go through all the illustrations till section number 94 from the book also, and then we will proceed further for the annual general meetings. All right, let's take a small break. All right, welcome back, all of you. All right, students, before we proceed further, I have a quiz for you. We have done till section 94. Section 92 to 94, we have done in detail relating to the annual return. So this is your beautiful summary made by ICAI for MGT 7, 7A, MGT 8. You have done a revision of MGT 8, also the certification to be given by the company secretary. So as we move ahead to section 95, here is a MCQ question for all of you. What do you mean by section 95? The register of members is prima facie or conclusive evidence about that the returns and section 88 and 94 has been complied with. So the question is, this is all we have done. Section 95 tells you that the register of members is evidence. What evidence it shows you? Is it a prima facie or a conclusive evidence? Oh my God, what are this? Is it a prima facie or conclusive evidence? You have to answer me. Khushbu, right. Ritu, right. Okay. What about others? Okay. Kiran is saying prima facie evidence. Ritu is saying conclusive evidence. All of you are confused. So I have to show you what it is actually. There is a difference between the word prima facie. Swati, right. Om Krishnam, Om Sagar, Komal Preet, Kiran, all of you are right. So Ritu and Khushbu are the only who have given the wrong answer. Others are all right. So prima facie evidence means that what is appearing means the name of the member. So in case of a depository, if your name is appearing in the register of beneficial owner, that means you are the owner. All right. It's okay. You don't have to be sorry about that, but you have to be very careful when you're learning the contents. Section 95 simply tries to tell you that all these registers, indexes, and annual return that you have understood from section 88 to section 94, they are prima facie evidence that all the matters have been inserted and has been complied. So prima facie means apparently that is appearing over there, that will be the correct. All right. So everybody is clear about that. Also, section 95 is done. Now we are moving. So this is your prima facie evidence. I have included in the PPT also. That shall be prima facie evidence that all the matters have been followed. Now let's move to a very, very important section, that is section 96, which I actually believe that when you start studying, whatever we have done till now is just a flip through of pages. When you will be studying and revising, you will be just flipping the pages and doing it quickly. You will be actually, if you ask me about the learning content, it starts from the annual general meeting. So it says every company, whether it is a public company or private company, except the 1% company. So this provisions is not applicable to 1% company. It says any other company other than OPC will hold annual general meeting every year. So annual, the name itself suggests that it has to be held once every year, annually. And the gap between two AGMs shall not be more than 15 months. So within 9 months of the opening of the first financial year, you have to hold your first annual general meeting. So when is the first annual general meeting to be held? Within 9 months from the first financial year. So you have opened your company from the close of the first financial year. So if I've opened up a company in 2022, my financial year closes on 31st March 23. So from the close of that financial year till 31st December, that means I should have hold within 9 months from the close of the first financial year, I need to hold the first AGM, that is first annual general meeting. And if I don't hold the meeting in the year of incorporation, but I've held my first annual general meeting as per the provisions, that is within 9 months, then is it okay? Is it compulsory to hold the general meeting in the year of incorporation? Please answer me. Is it compulsory to hold the annual general meeting in the year of incorporation? Yes or no? What is the correct answer? It's appearing in front of you on the screen also. Kiran is still saying yes. It is there on the screen, child. Read it. it shall not be necessary for the company to hold annual general meeting in the year of incorporation. So you incorporated a company on year 2022, the year ended on 31st March 23. So within 9 months, that is till 31st December 23, you have held the meeting. It's okay, even if you did not hold the meeting in 22, because within 9 months from the close of the first financial year, it is important that the meeting shall be held. First annual general meeting, everybody is clear. Year of incorporation, you can avoid, but within 9 months, you have to hold the first annual general meeting. Om Sagar and others, everybody's correct. But yes, next shall be held within 6 months. All right. So subsequent annual general meeting should be held within 6 months from the close of the financial year. So the gap between the two AGMs shall not be more than 6 months. That is what is important. Registrar may for any reason extend the time period for which the annual general meeting to be held, but this extension shall not be for more than 3 months. So can the registrar extend the general meeting time period, annual general time period? Yes, he can extend the time within which the annual general meeting shall be held. But for how longer the time period can be extended? It can be for 10 months, 9 months, or 3 months. The extension which registrar gives for the holding of annual general meeting shall not be more than, absolutely correct, shall not be more than 3 months. So three type of provisions we have learned over here. First, it is not necessary to hold the annual general meeting in the year of incorporation, but the first AGM shall be held within 9 months from the close of financial year. The gap between two AGMs shall not be more than 15 months. Why it is saying? Because the two AGMs shall be subsequent annual general meeting has to be held within 6 months from the close of the financial year. And then if the registrar feels like giving an extension, it can give extension, but not more than 3 months. Excellent answer. Everyone has given the correct answer to this one. Let me see those who are sitting over there with us on the portal also are answering it correctly. Very good. Very good, Pooja and Vidya. Jayashree. Yes, absolutely correct. If the company started in Jan, they can hold in the next financial year. Ms. Jayashree, absolutely correct. All of you are correct, children. Good. Uni Krishnan. Nice. Swati, Vidyashri, all of you. Okay. So now annual general meeting can be called on any day. Can we call it on Sunday also? Please tell me. It says any day during business hours in between 9 a.m. to 5 p.m. What is the time period that we have given? 9 a.m. to 6 p.m. and on any day which is not a national holiday. Can we hold the annual general meeting on Sunday? Somebody saying yes, somebody saying no. Is Sunday a national holiday? Yes? Tell me. Can we hold it on Sunday or no? Any day during the business hours on any day other than the national holiday as declared by central government. It means if it is yes, Som Sagar has tried to play very safe. He said yes, if it is a working day. So if it is not a, Abhishek Singh is also right, Sunday, if it is not a national holiday. Ritu says yes. So very nice, children. You have learned how diplomatically you have to handle law now. So absolutely correct. You can hold it on Sunday because the provision says that it shall be held within business hours, that is 9 a.m. to 6 p.m. on any day. So what is the underlining line? On any day, which is not a national holiday. So national holidays, 15 August, 15th August, 26th January and 2nd October is the national holiday. So as far it is not, or it is the holiday declared by central. So you cannot hold the AGM on that date, but Sunday can still be held an annual general meeting if it is a working. What is the place for holding the annual general meeting? It shall be held at the RO of the company or any other place within which the RO is situated. So any other place within which the city, village, in which the registered office of the company is situated. In case of unlisted company, it can be held at any place in India, provided the consent by all the members in writing have been taken. Or either by electronic mode, means by WhatsApp messages, everybody has consented, okay, fine. In case of an unlisted company. So AGM has to be held, if it is a listed company, it has to be held mandatorily at the RO of the place or some other place within which the RO is situated. Okay, so wherever the city, village, town, where the registered office of the company is situated. In case of unlisted company, it can be held at any place in India, not outside India. Please make sure you're not going abroad. You cannot say that I'm holding annual general meeting, I'm an unlisted company, I'm holding annual general meeting in USA. No. It can be held if you have Delhi, the registered office, but if you're holding it in Pune or Bombay or Bangalore, any other place in India, then consent has to be taken in writing by all the members. And in case of a government company, the annual general meeting shall be held at the registered office of the company or such place where the registered office is situated, or any other place which the CG will approve. So if I'm a government company, then my annual general meeting will be held where RO is situated, or any other place which the central government. So here I'm a government company, I need the approval from the central government if I'm trying to change my place of holding the annual general meeting. Everyone is clear. Let's do certain questions also. So if I am a company which is an unlisted company and my registered office is in Bombay, can I hold the annual general meeting in Bangalore? Please tell me. I'm a company whose registered office is in Bombay. I want to hold my annual general meeting in Bangalore. What is required to be done by me? Can I do that? Yes, yes, but reason, yes, that's fine. Komalpreet Kaur has given the correct answer. Om Sagar has, you cannot simply say yes, ma'am. Yes, only if all the members have given their consent in writing or by electronic mode. Now we have to learn how to write the answers in the exam. पेपर में अगर आप सिर्फ yes लिख कर आ जाओगे इसका, if you just write yes, then it's wrong. He will not give you marks. Just not yes. No, you have to give how. Yes, if all the members. So underline the word in your study material or your notes that all the members is important. So examiner can ask you if out of 1,000 members, 800 have said yes, all the members. Consent has to be taken in writing for all the members if you're holding the annual general meeting at any other place. Clear? Provision of AGM is absolutely clear. Section 96. So these are the things which you have to remember. Okay? All the members and government company make its approval, central government's approval has to be taken. Now, ma'am, what is section 97? We have understood annual general meeting. We are holding the annual general meeting. 9 months, 6 months provision is clear. Not extension more than 3 months. Place of ho gaya, timing ho gaya, everything is done. What is tribunal doing over here? So, my dear students, if default is made, your company is not holding the annual general meeting, then tribunal will come and say that, first of all, notwithstanding anything which is contained in the act or articles. If your articles are saying something, then follow that. If act has given you the provision of section 96, you will follow that. But if you have defaulted in holding the annual general meeting as per section 96, then tribunal on an application. One of the members felt very annoyed. He said that the company is not holding the annual general meeting, and he went and made an application to the tribunal. Then tribunal on this application will either call or direct the members that you should call the annual general meeting and give the consequential direction. So when the power has been given to the tribunal to call the annual general meeting, number one, when you have defaulted in calling the annual general meeting and application has been made by any of the member, then tribunal will direct the company to call the annual general meeting and give such consequential directions that you have to hold the meeting with such actions. Directions may also include that one of the member of the company in a person or proxy shall deem to. So now tribunal said, okay, fine. After 5 days, you all are going to hold the annual general meeting and say only one member is present in the meeting. Then also he shall deem to be the quorum for the meeting. What is the quorum? When we started the class, you told me, ma'am, quorum is the minimum number of persons required to be present in the meeting. So we will be doing in a while the detailed section about the quorum and proxy. But here, section 97 provision is very important because tribunal has told you to hold the meeting. Now, even if one of the member in person or proxy is present, he shall deem to constitute a meeting. It will be considered that the meeting has been happened. Okay, general meeting held under section 1 shall deem to be the annual general meeting of the company. Meeting which is held under the directions of the tribunal shall deem to be the annual general meeting. So what are the 3 points you have to remember in section 97? Number 1, you have defaulted in section 96 of holding the annual general meeting. Company, any member has made an application to the company, to the tribunal, then tribunal on such application will pass an order and give directions for holding this annual general meeting. And on such directions, if you have held the general meeting, it shall deem to be the annual general meeting of the company. And 4th point is, even if one of the member of the company in person or by proxy is present, he shall constitute a meeting. All right. Clear? Power of annual tribunal to call annual general meeting tha, a power of tribunal to call other meetings. What is the other meetings? Apart from annual general meeting, what happens? Section 98 will be for what? You tell me. It is your revision. You know that. One, you have annual general meeting. What are the meetings you have? Meetings of the members. What meetings of the members? What meeting it is talking about? It is talking about the extraordinary general meeting. When will the tribunal call the extraordinary general meeting? Very good, Rishabh, Kiran, Om Krishna, all of you. Class meetings, Om Sagar is saying. Okay, class meetings. Nahi, it is talking about Komalpreet, correct. Extraordinary general meeting. Okay. Yes, good. So section 98 is specifically applicable to EGM, not AGM. It says for any reason, if it has become impracticable to call a meeting other than annual general meeting, to likh lena other than annual general meeting means here we are talking about extraordinary general meeting, then, or you have not called the general meeting as per the act or by the articles, then either suo moto or on an application made of the director of the company, tribunal will order the company to hold the meeting and conduct in such manner as it thinks fit or give the directions as the tribunal thinks expedient. Means जैसे भी ट्राइब्यूनल को ठीक लगे, tribunal will give the directions that the meeting has to be held. No, Kiran Mishra, it is not talking about board meetings over here because please read the heading. It says power of tribunal to call the meeting of members. It's not saying the meeting of directors. That is part of your CA final. When you go over there, you will study about detail about the directors, how the meetings are being held. Here we are talking about the meetings of the members. All right. So here it is extraordinary general meeting. If you have failed to hold the annual general meeting, then section 97 is applicable. If you have failed to hold the extraordinary general meeting as per the act or as per the provisions, then section 98 tribunal will order that such meeting shall be held. Any meeting held under as per this section shall deem to be the meeting company duly called conduct. Shall deem to be a meeting of the company duly called, held and conducted. मान लिया जाएगा कि as if the company has conducted this meeting and one member of the company or proxy shall also constitute a meeting of the company. So if I ask you a question that tribunal directed the company to hold the extraordinary general meeting, which section is applicable? Section 98. ठीक है. Only one of the member in person was present to constitute this meeting. Can we consider it to be a valid meeting? Under section 98, tribunal gave the directions to hold the company to call a meeting because it failed to call the extraordinary general meeting. So now only one person in person was present. Can we say that he shall deem to constitute a meeting? Yes or no? Please answer me. Why only one person? Kiran says yes. Om Sagar says yes. Pooja says yes. Devyanshi Garg is saying yes. Good. Very good. All of you are saying yes, if directed by tribunal. Very good. So if directed by tribunal, very good, Komalpreet. Ritu, Yamin, all of you are correct. So under section 97 and 98 are the only exception where only one person present shall also constitute a meeting. Because in a while, I'll be changing my statement when we'll go in the quorum of the meeting. One person otherwise cannot constitute a meeting. The only exception has been given under section 97 and 98, where the tribunal is calling the meeting, there only one person, either as a proxy is present. Proxy means somebody is going on your behalf. Say you must have attended lectures in the college and then you say that my friend is absent, but when teacher is taking the attendance, you quietly say present ma'am. You do like this, at times you have done this, so that is your proxy attendance. Means the person is actually absent, but you are helping him marking a proxy. So similarly, in Companies Act also, in meetings also, you have a proxy person who is actually not present in the meeting. So you give his attendance in the absence of the person. So that is a proxy. We will understand in a while what is proxy. Section 99. Contravention of section 96. What is section 96? Annual general meeting. What is section 97? Power of tribunal to call the AGM. What is section 98? You tell me. What is section 98? Power of tribunal to call EGM. If you have contravened any of these provisions or directions of tribunal, then maximum penalty of fine 1 lakh in case of a continuing default, 5,000 for every day during which the default continues. Section 99 simply tells you about the penalties about all these three sections. If you have defaulted, what is the penalty for that? Good, Swati and Abhishek, correct answers. Well done. Now we move to the very, very important sections. That is section extraordinary general meeting, section 100. But this is exactly the extract taken from your study material, just to give you a hint and introduction that what is coming up in further presentation. Number one, we will be talking about the notice of the meeting. So before convening any of the meetings, so this is your prerequisites of a meeting. Those who are doing BCom students also, this is one of the favorite examiner questions when you do this topic in BCom. These questions generally come, and in CA Inter also, a straightforward question can come. What are the pre-requirements of the meetings? So if examiner give you such kind of questions, such kind of points, examples, definitions, you can give, and each and every point has to be elaborative. Although this lengthy question will not come, but it can come in brief summary also, 6 marks question. Then two to three lines for each point you can write and explain in your own words. So what are the pre-requirements for holding any meeting? Number one, before the meeting, you have to send the notice for the meeting under section 101. So in a while, we'll be doing what is the time period, 21 clear days, 14 clear days, all those notice time period we'll be discussing. What is the meaning of explanatory statement? So where you are holding a regular meeting, that is your annual general meeting, there we are sending a notice to the members. But whenever extraordinary general meeting, so word extra is with explanatory. So when the extraordinary general meeting are being held, then the explanation has to be given along with that under section 102, that why we are holding an EGM. So we will understand what is an EGM, why it is held. So in case of EGM, explanatory statement should also be given. These are the things which have to be done before the meeting. During the meeting, you have to make sure under 103 the quorum is present, minimum number of members, how many minimum number of members shall be present. I'll be asking you, you will be answering. Who will be the chairman of the meetings, how the votes will happen, by show of hands or by polling or by electronic. That is your part of next session. Resolutions, how the resolutions will be passed, what is your ordinary resolution, what is your special resolution, what is the ordinary business, how the special business is conducted. All these things are happening during the meeting. So before doing the meeting, I'll send you a notice or the explanatory statement for extraordinary general meetings. During the meeting, quorum, chairman, proxies, voting, and resolutions. After meeting, what will you form? You will form the minutes of the meeting. That is the most important section. 110 will make the minutes of the meeting. Then inspection can happen, and maintenance and inspection of the documents. In what form you can inspect the documents. All that is given under section 120. All right. So let's begin with section 100. What is extraordinary general meeting? Board of directors, board will call the extraordinary general meeting whenever it deems fit. Now you are into clothes business, you're a company, you're into sale and purchase of clothes. So you're having annual general meeting every year, how the import export will be done, how this business will be conducted. But for any special business that has come up, any extraordinary thing that the company is planning to do, board is the main management conductor holding of the company. They will decide that, okay, now we have thought about something out of the world, something is different line or some special business we are trying to open up. We need to call an extraordinary general meeting. Provided the extraordinary general meeting of the company other than wholly owned subsidiary incorporated outside India, it shall always be held at a place within India. If you are a wholly owned subsidiary of a company incorporated outside India, then you can hold it outside, but otherwise it will always be held inside India. So if you're a wholly owned subsidiary of a company, companies in US, and now this Indian company, this is wholly owned subsidiary of US company, you can hold the EGM outside India, but otherwise every EGM of the company incorporated in India shall always be held within India. So number one, board is calling this EGM and it has to be held within India unless you are wholly owned subsidiary of company incorporated outside. Number two, at whose requisition board of directors are going to call this meeting? There are two parts. Number one, company having a share capital, company not having a share capital. If the company is having a share capital, then at least 10% of the paid up share capital as on the date carrying of the voting right. If 1/10 of the members who are holding the paid up share capital of the company, or if the company is not having the share capital, at least 1/10 of the total voting power, they can call for the requisitionists. Who are the requisitionists? Requisitionists are the people who are requesting the company to call the meeting. So they will give an application to the board of directors. Board of directors, if board of directors have received the request from the at least 1/10 of the paid up share capital of the company holders, or if company is not having paid up share capital, at least 1/10 of the total voting power number of members, or having at least 1/10 of the total voting power, they will make a requisition. Then only board will hold the extraordinary general meeting. Requisition shall set out the matters for the consideration for which the meeting is to be called. So requisition will tell that these are the matters. So we have decided to do expand a business or any special line of business we have thought of, and it will be signed by all the requisitionists and will be sent to the RO of the company. So what are the three things? Board of Directors going to call the AGM shall be held within India after receiving a request from the requisitionist, and requisitionist 1/10 of the voting power or 1/10 of the paid up share capital, whosoever are the requisite, they have to give the reasons for holding this meeting, and they will also sign the requisitions. Within how many days board will proceed to call the meeting? Please answer me, children. It is your exam. Quickly tell me. Requisitionists have sent a requisition to the board of directors. And now, within how many days the board of directors shall proceed to call the meeting? Please tell me. Okay, Pooja, when we reach over there from the study material, we'll talk about this point also that you have mentioned, okay? All right. Within how many days the board will call the meeting? Within 21 days from the date of the receipt of ballot requisition, we shall call, but not later than 45 days. So within 21 days, you shall call the meeting, but it shall not exceed more than meeting to be called on day not later than 45 days from the date. You shall not pass 45 days from the date. 45 days has passed, then the procedure will changes. But within 21 days from the date of ballot request that you have received, company shall convene a proper extraordinary general meeting. If board does not call this meeting, then requisitionists will themselves call and hold the meeting within 3 months of the date of the requisition. So board did not call the meeting, then within 3 months of the date on which they have made the requisition. So if I have made you the requisition on 17th Jan, so within 21 days of 17th Jan, this meeting should have been convened. If the board fails to convene the meeting, then within 3 months of the 17th Jan, the requisitionists will themselves hold a meeting, will themselves call and hold such meeting. Meeting held by the requisitionists will be in the same manner as the meeting held by the board. It will be considered as the same meeting as they would have been held by the board. Reasonable expenses incurred by the requisitionists in calling a meeting shall be reimbursed by the company, and also this amount will be deducted from the remuneration under section 197 of directors who were in default. So section 197 is related to your remuneration of directors when you study in CA final. Here he's just trying to tell you because it was director's responsibility to call the meeting. They have failed to call. Now, whatever expenditures requisitionists have incurred in calling, that will be deducted from the fees that we are paying to the directors. From the remuneration payable to the directors under 197, that amount will be deducted to those who defaulted in calling this meeting. All right, clear? Now, extraordinary general meeting, how you are calling? Calling of extraordinary general meeting by requisitionist has to follow certain procedure. Requisition has to be made in writing or through electronic modes at least 21 days prior to the procedure. How they're going to call the meeting? They will make the requisition. Notice has to be given within 21 days that we propose to call the proposed date of the extraordinary general meeting. This is the date on which we propose to call the extraordinary general meeting. Notice will specify the date, time, place, and hour of the meeting and shall contain the business transactions to be transacted. What all business we are going to transact, and shall be convened at the register office of the company, except or the same town and village where the RO is situated, and shall be convened on any day except national holiday. So it can even be on Sunday. Clear? So how the meeting is to be called? Requisitionist, first of all, 1/10 of the requisitionist that we have discussed, board will call. If board fails to call, then this is talking about how the requisitionist himself they're calling. They will send in writing or through electronic modes 21 days clear notice. That is the notice of the meeting that they're proposing. And the notice will specify every date, place, and the hour of the meeting, where the meeting has to be conducted. Everything has to be written. If it is a special resolution, then please follow section 114 subsection 2. Can anyone tell me what is written over there? Notice shall be given as required under 114. If the resolution is to be a special resolution, although we will be doing 114 in detail, but how many of you can recall? It says the notice shall be given as per the provisions of 114 subsection 2. What is the meaning of that line? It shall also be signed by all the requisitionists or by the requisitionist who has duly authorized. So all the requisitionists will also sign this notice. Okay, who is the correct one to give the correct answer? OR SR. Okay. Om Krishnam is saying, ma'am, please choose what you want to choose, OR or SR. So whenever special resolutions are being passed and explanatory statements have to be given, a special notice has to be sent. That is what we will be doing in detail under 114. As of now, he's simply trying to tell you when SR needs to be passed, the notice has to be followed as per section 114. Notice shall also be signed by all the requisitioners. No explanatory statements to be given to the notice of extraordinary general meeting. They shall disclose the reasons for which they propose to hold the meeting. No explanatory statements need to be annexed. So you don't have to give any detailed statements along with the notice, but it shall disclose in detail the resolutions which they propose to pass in the meeting. Notice of the meeting shall be given to those members whose names are there within 3 days on the receipt of the valid notice of the meeting. Now, what is it trying to tell you? This is whole of the procedure how the extraordinary general meeting is being called by the requisitionists. Shall one, then they're not accepting. Yes, Om Sagar, that's absolutely correct. So it says notice of the meeting shall be given to those members whose names appear in the within 3 days on the receipt. So within 3 days, your notice has to be given on the receipt of the valid requisition. So company has received the requisition from the requisitionist. So within 3 days, they shall give the intimation to those members whose name are there in the register of members. If the meeting is not convened, then they will have the right to receive list of members. Then they will go and say that please give us the list of members, their address and number of shares held. And on the 21st day from the date of receipt, together with the requisition before the expiry of 45 days from the date of receipt. So if 21 days, company was supposed to call the extraordinary general meeting in 21 days. Okay? Board of directors failed to call the meeting. Now from the 21st day, requisitions will go and they will ask for all the details from the register of members, that who all are the members, what is the register address, number of the shareholders, and they will send the notice, but not later than 45 days. So within 21st till 45 days of the date of receipt, this whole procedure has to be done by the requisitionists themselves. Notice will be given by speed post or registered post or through electronic mode also they can be sent. Accidental omission to give notice or non-receipt by any of the member will not invalidate. So there are few members who did not receive, their email box was full, they did not receive the notice electronic mode, or their address has changed, they did not. So that will not invalidate the proceedings of the meetings. You cannot, accidental omission means not intentionally you have done. By mistake, there was something. So your email was full, you did not receive the notice of the meeting, you failed to attend. So that will not invalidate the proceedings of the meeting. Accidental omission of the notice to any of the member will not invalidate the proceedings. Clear? Everyone is clear about the extraordinary general meeting. I will just show you the AGM from the study also once. So we have done section 96, 97, 98 has been done by you. 95 we have done. So this is your general meeting. It is of two types of meetings: board meetings, class meetings, held by preference shareholders, debenture holders. General meeting is only of two types, and general meeting or EGM. In case of specified IFSC public company, 101 shall apply in case of this company unless otherwise specified in the article. So you were asking about notice 101. We will discuss this in 101 notice. I hope extraordinary general meeting everyone is clear because we have discussed that in detail. This is all about your 101, that is notice of the meeting that you have to send. We will do illustration 4 after this. All right. So notice of the general meeting, section 101 completely tells you about what is the meaning of the notice of the general meeting. In order to convene any meeting, 21 days clear notice has to be given through writing or electronic mode or as may be prescribed. So if I send you the notice on WhatsApp or any other electronic mode, as may be prescribed means it has been authorized by the company, then yes, 21 days clear notice you have given through such mode, it is absolutely correct. The date on which the notice is served and the date of the meeting are excluded while sending the notice of the meeting. So what does 21 clear days means? Can anyone tell me what is the meaning of 21 clear days? I give you an example. If the meeting was to be held on 25th of August and the notice has been served on 3rd August, is it a valid meeting? Yes or no? Please do your calculations. It says 21 clear days notice. The day on which the notice has been served, that is 3rd August, and the date on which the meeting is to be held, that is 25th August, are to be excluded. So have I sent the clear cut notice? So you will count the dates from 4th August till 24th August. So it is clear 21 days notice. So yes is the correct answer. Very good. Om Krishna. Swati, correct. Yes. Except we will exclude these dates, and whatever dates are balanced from 4 to 24th is clear 21 days. So 21 days notice has been given. In case a general meeting has been called after giving shorter notice, if consent and writing has been taken of not less than 95% of the members who are entitled to vote. What will happen if you want to say, it says that in case of any other general meeting, first of all, it is not talking about the, it is talking about the annual general meeting. So if you're calling the annual general meeting and the notice of shorter period has to be given, then consent of 95% of the members who are entitled to vote has to be taken. Clear? In case of any other meeting, means other than annual general meeting, say EGM. So for EGM, if you're sending less than 21 days notice, then company having share capital, 95% of the members holding paid up share capital, or not having share capital, then the members holding 95% of the total voting power, consent has to be taken in writing, then only shorter notice can be given. So my question to my class is, can I give a notice shorter than 21 days? Yes, ma'am, provided consent has been taken. If it is an annual general meeting, how many members have to give the consent? In case of annual general meeting, for giving the shorter notice, consent has to be taken from how many members? Answer me. Members holding not less than 95% of the total voting power. Very good. Correct answer given by all of you. All right. So notice will again specify all the date, place, and hour of the meeting and will contain the statement of the business to be transacted. You have already informed what business you are doing, then you don't need to give any explanatory statement. Very good. Correct answer given by everyone. And notice shall be given to every member of the company, every auditor of the company, every director. So member or his legal representative in case of a deceased member or the insolvent person. If the person has been declared insolvent, then his official assignee will receive the notice. If person has died, his legal representative will receive the notice, and every member of the company has to be given the notice. Every auditor of the company. So member, auditor, and director of the company. Abbreviations you can remember, so that member, auditor, and director has to be given the notice of the meeting. Very important question from the viewpoint of MCQ also. Auditor of the company was not given the notice of the meeting. It has to be given. Auditor will also be given the notice. But any accidental omission, will it invalidate the meetings? Yes or no? Any accidental omission means by mistake, if any notice has not been given to the members, will the meeting remain valid, or yes or no? No, ma'am, it will not invalidate. Swati, Komalpreet, Kiran, all of you are correct. Om Krishna. No, the meeting still remain valid even if the notice has not been given to one of the members. Now, let's quickly read this illustration 4. Mr. Abhinav, a member of Elixir Logistics, filed a complaint against the company for not serving him the notice. So I have just told you every member shall be given the notice, but notice was not given to him. Company gave the proof that they had sent the notice by way of email inviting them, but he leaks that he never received the email. Is company liable for contravention under 101? You all rightly mentioned me right now. No, ma'am, he will not be liable. But how we have to write it? No need to remember as per rule and all. What will you write, my dear students? As per the provisions of Companies Act 2013 and rules of Companies Management and Administration Rules 2014, it is company's obligation that it transmits an email, but the company will not be held liable for failure of transmission beyond its control. Now, I have sent you an email. If you have not received it, that is your headache. It's not my headache. How will I make sure that your email box is not full and whether you have received? Failure of transmission is not company's default. If a member who is entitled to receive fails to update the relevant email address or to the depository participant, the company will not in default for not delivering the notice. Therefore, company will not be held liable for any failure in transmission, which is beyond its control. or in case where Abhinav did not update. Maybe he has changed his email address, he has not updated, or its company will not be considered in any kind of default. Here it is talking about the shorter notice. You have already answered me. 95% of the shareholding has to be seen. So the paid up share capital of Akash Soaps Limited is 50 lakhs divided into 5 lakhs of 110 shares. Directors are desirous of calling EGM by giving a shorter notice of less than 21 days. 60% of the members holding 40 lakh accorded their consent to the short notice. Can we call the EGM? The answer is, please tell me the answer. Can we call the AGM? 60% of the members holding shares worth 40 lakh have given the consent. They have 5 lakh shares, 50 lakh shares. Can we hold the EGM? Can the EGM be called valid, yes or no? Give me answers also. Don't say yes and no. What is the exact answer? So it says consent to call by shorter notice, 60% has been given. So 40 lakhs out of this are giving. That is, whereas the requirement is at least 95% has to be giving. So he's trying to confuse you. He's written 60%, but if you actually see the 40 lakhs of 50, it is 80%. Against the requirement of the majority of numbers should not be less than 95% of the holding paid up share capital, which gives them the right to hold. Must have consent. Therefore, it cannot be held. Why it is not being held? Because 95% criteria has not been met. Very good, Swati Om Krishnam, at least 95%. All those who have written, very nice. Abhishek Singh, Khushbu, all of you are giving the correct answers. Wonderful students. I'm so happy and I'm really enjoying teaching you because you are actually responding in such a nice way. That means that makes me feel proud that you have really revised your content. So I hope you all are enjoying the session, doing side by side question answers revision also we are doing. So let's take a small break over here. And in this break, you have to read from till section 101. Yes, Kiran Mishra, all of you have given the correct answers. Wonderful students. Criteria is not met. Good. So my question to you is, for example, the AGM was to be held on 7th November and the notice was posted on 16th October. Is it a valid notice? Yes or no? The AGM was to be held on 7th November and the notice was posted on 16th October. Is it a valid notice or shortfall of the notice? Yes or no? Please tell me. It's not a valid notice. Why? Reason? Give me the reason. 21 clear days has to be considered. You have excluded both these dates. After excluding, it comes down to 19 clear days. So it is not a valid notice. 21 clear days notice has to be given even after excluding the date of meeting and the date on which the notice has been served. The clear 21 days notice shall be following. Good, Kiran. Yes, it's not a valid notice. Let's take a small break over here, children, and then we'll continue because we have the session till 1:30 and we'll be finishing off section 102, 103, 104 after the small break. Let's take a small break here. All right, welcome back, students. So I hope you have read till section 101, 102. So now we're going to understand few of the explanations given for 101 are here. You can just read them from my presentation. Electronic mode means any communication which has been sent by company through a secured computer program. I told you if there is any problem in transmission, the person has not received just because of this internet doubts or problems, or his address was not updated, then it is not company's fault. We have just done illustration 4 also with respect to this. Company shall provide advance opportunity at least once in a financial year to register their email address and the changes, and respecting all those members who have got their email ID to update a fresh email ID also. So the company will also give them a chance, but then it is the responsibility of the shareholders to intimate the company. Subject line and email shall state the name of the company, notice of the type, and the place on which the meeting is rescheduled. Notice shall be placed on the website of the company also, or as the website notified by central government, where the notice is sent by post. It shall deem to be served at the expiry of 48 hours after the letter containing the same is posted. So within 48 clear hours, the notice of the meeting shall be received once it has been sent by post. All right. So section 102, now we are going to start with explanatory statement to be annexed along with the notice. Before we start with this, I want to tell you that there are two types of businesses that we do in the meetings and Companies Act: ordinary business and special business. Can you tell me what is the ordinary business that we do in the meeting? Any business, if you read in the study material, it says any business in case of AGM, all the business shall deem to be special business other than these four. So these four are the ordinary business. So section 102 includes the following business to be transacted at the annual general meeting of the company, that is ordinary business. Quickly tell me, students, I hope I'm audible to all of you. I am not receiving your answers. You have to tell me what is the ordinary business of the company. If I say declaration of dividend, is this a special business or ordinary business? Tell me. Yes, Devyanshi, Pooja, all of you. Absolutely correct, Miss Pooja. The clarification will be applicable only when the articles provide. Okay, so when all the provisions as per the articles and as per the act, when it says, so if articles are providing something specific, that is what we have to follow in that case. Vidya Shraddhe, good for 21 days notice that you have answered. Divyanshi, Pooja, all of you, please answer me. Declaration of dividend is an ordinary business or special business? Adoption of reports, ordinary business. Okay, now I'm receiving your answers. Very good. Om Sagar, Kiran, Yamin. Appointment of director? Yes, good. And appointment of auditors, that is also ordinary business. Excellent, children. So the following business are transacted at the annual general meeting, considering the financial statements and the report of directors and auditors, declaring of the dividend, appointment of the directors, and appointment and fixing of the remuneration of auditors is all the ordinary business that is transacted. And ordinary business is transacted by AGM or EGM? Answer me. Dividend, auditors, directors, and reports of directors, consideration of financial statements. Absolutely correct. Very good. All these are ordinary business. Komalpreet, Abhishek Singh, Swati, good. Kiran, good. All these are transacted at AGM. Ordinary business are transacted at AGM. And special businesses, what about the special business? Any business in case of AGM, all the business shall deem to be a special business other than these four. So any business which is other than the above mentioned four categories shall deem to be the special business. So if I ask you, if I am doing a meeting, ordinary general meeting for transacting of the fixing of the remuneration of the auditor, is it ordinary business or special business? Fixing of the remuneration of the auditors is an ordinary business or special business? It is an ordinary business. Very good. All of you have given the correct answer. Not just the appointment of auditors, also fixing of the remuneration, appointment of directors, dividend declaration, and consideration of financial statements and report of directors and auditors. Learn it by heart, because one of the favorite MCQ of the examiner most of the time is to give question from this, and also it is very important. Section 102 is very, very important. You should read each and every line which is given under this section. All right. So all these kind of business we have discussed. Any business other than these will be the special business, and also all the business of extraordinary general meeting is always a special business. Special business is to be transacted at the company's general meeting, then explanatory statement has to be given. I just told you that when you're sending a notice under 101, explanatory statement is not compulsory, but when you're doing a special business, then an explanation has to be given. It must specify the nature or concern of interest, every director and the manager, every key managerial personnel, relatives, any other information which help them to understand what items of business are to be transacted and what decisions will be taken. So all the matters, anything which that affects the business, all the important facts have to be disclosed in this explanatory statement whenever any special business is to be transacted in the company's general meeting. And what happens if you do not disclose or give insufficient disclosure? Then all the directors, promoters, manager, or relatives who hold this beneficial interest shall be liable to compensate the company to the extent of the benefit received by it. So if you have not disclosed whatever interest or first of all, it says special business to be transacted and explanatory statement to be given. Explanatory statement shall disclose all the material facts which affects the nature of the business, and it shall tell about all the directors, manager, key managerial personnel, and the relatives, and what all information is required to be given, what kind of business we are going to transact in the special business. If such disclosure has not been given, then whatever benefit they are accruing, means any benefit which is arising to the promoters, directors, they shall hold that benefit in the trust of the company, and they will be liable to give it back to the company. Say, for example, there is a shareholder, there is a director, Mr. A, who holds interest in company ABC Limited. Now, if non-disclosure of such kind of interest has been made, then he will be liable to compensate the company for that. Means now ABC Limited is holding this interest as a trust for him, and all the benefits that he is having in the company has to be given back. So that is very, very important. Non-disclosure of the effects, any non-disclosure which has been made, the person who was entitled to the benefits will be liable to pay it back to the company. Provided that any item of special business that relates or affects the company, extent of shareholding, or any other key managerial personnel, shareholding is 2% or more than the paid up share capital. Now, what is it trying to tell you? First of all, we have understood there is an ordinary and special business. For special business, we have to send an explanatory statement. That statement shall disclose all the nature of interest or finance or otherwise of all the directors and key managerial personnel. Now, if you have not disclosed that interest, the company is holding all that beneficial interest as a trustee for you, and you are liable to pay it back to the company. Now, any special business item which is affecting any other company, say for example, that particular business that you're doing, if there is a transaction between two companies, say A Limited and B Limited, and you are key managerial personnel of A Limited, and you're also holding more than 2% of the paid up share capital of B Limited, then this kind of interest needs to be disclosed in the explanatory statement. If any special business is to be transacted, any shareholder, promoter, director is disclosing their interest. If I am the company, if I am a director, I'm a shareholder, it is affecting my one company, and also I'm having 2% or more of the paid up share capital of that other company, then that interest has to be disclosed in this explanatory statement. Any item refers to any document which is to be considered at the time, and the document can also be inspected, should also be specified. What all documents are to be included in this explanatory statement and how the inspection can happen, all these details have to be given under section 102 explanatory statement. Is that clear? So till now, since morning, we have been doing all the penalties. So again, there is a penalty if the provisions of this section 102 are not complied, then every promoter, director, manager, and key managerial personnel and the officer who is in default shall be liable to a penalty which is higher of these two. What is the penalty? 50,000 rupees or 5 times the benefit that accrued to these people. Whatever is higher shall be the penalty in this case. So whatever benefit is acquiring by the promoter and director, so that is very important. That's why it says the explanatory statement shall disclose all the nature of interest and benefits that are applicable to these directors and managers, because 5 times of the benefits accruing to the promoter director or 50,000 rupees, whichever is higher, will be liable for any contravention of section 102. All right. So all these special businesses are always transacted under EGM. There is no ordinary business. Do we transact ordinary business in EGM? In extraordinary general meeting, do we transact Abhishek, it is saying 2% of the shareholding. It says that if I am a shareholder in one company and I'm holding more than 2% of the share capital of another company, so it is affecting the interest of two companies, then these kind of interest also shall be disclosed. Basically, you have to disclose whatever nature and interest financially or otherwise you are having in the company. Okay. Very good, Swati, Sagar, Yamin. All are correct. All the special businesses are only transacted in the extraordinary general meeting. No ordinary businesses done in the extraordinary general meeting. All right. So now another very, very, very important section of this chapter, that is section 103, quorum for the meetings. What is the meaning of this first line? Unless the articles provide for larger number, the quorum shall be less. Can we say that the articles of the association can provide for a larger quorum? Yes or no? Articles of association can provide for the larger quorum also. Yes or no? Yes, ma'am, is the correct answer. So, although the quorum for company having less than 1,000 is 5 members, but articles can still say that if my company is having less than 1,000 members, there shall be at least 10 people personally present. Articles can provide for the larger group. And this kind of question is going to come in the MCQs. They will give you this provision, and children generally don't even read this line, each and every line of the study material, because we have taken the content from the Bare Act. So you have to read it. Unless the articles provide means articles, so likh lo usko side pe apne hand se, write it down. Articles can provide for the larger number of quorums. So otherwise, less than 1,000 number of members, 5 members shall be the quorum. But if articles provide 10, then 10 has to be personal. Then 10 shall be the quorum for the meetings. What is the quorum as per the Companies Act? If the number of members are less than 1,000, then members personally present. 1,000 to 5,000, more than 1,000 to 5,000 is 15,000, more than 5,000 is 30. So if my number of members are 1,000, what is the quorum to be present? Question to all of you. If my number of members are 1,000, what is the quorum to be present? 5 or 15? Very good. Intelligent class, huh? If my quorum is 5,000, what is the, if my number of members is, 5,000, what is the quorum to be present? $15 is the correct answer. 5,000. So till 5,000, 15, and more than 5,000. If my quorum is, if my number of members is 10,000, then my members personally present dash will be the quorum. Number of members 10,000, then the quorum will be 30 members. All of you have given the correct answer. Beautiful. This is in case of public company. In case of private company, what is the quorum, children? 2 members personally present shall be the quorum for the private company. Clear? So 2 in case of private, public company 1,005, 1 to 3, 5,000, 15, more than 5,000, 30. Learn karna padega, no alternative for that. And you have already learned it because you have answered me beautifully. Adjournment of meeting for want of quorum. What is the meaning of adjournment? Can we adjourn the meeting? Adjournment means postponing the meeting. Can we take the meeting to another day? Can we postpone? If the quorum is not present within half an hour from the date of time appointed for the meeting. So we have decided that the quorum shall be present. The meeting will be held. The notice has mentioned on 15 January at 5 p.m. the meeting will be held. If the quorum is not present by 5:30, at the same time, same place, same day, the quorum meeting shall stand adjourned to the next week. So it was Wednesday, 5 p.m., 5:30 p.m., quorum is not present. So next week, Wednesday, same time, same place, 5 p.m., meeting will be adjourned. It will be held, or any other date and time which the board will decide. Is this clear? Adjournment of meeting is clear. So if the quorum is not present within half an hour from the appointed time, the meeting shall be adjourned. And if this meeting was called by the requisitionists under section 100, what was section 100? AGM, where the requisitionists were calling the meeting. Remember, 1/10 of the paid up share capital or 1/10 of the voting powers, if they have called the meeting, so requisitionist said, shareholder, please come for the meeting, and the other shareholder did not turn up. The meeting is cancelled. It is not adjourned. You are yourself requisitionist. You are only calling the meeting. You have requisition for it, and now you're not coming for the meeting also. So the meeting stands cancelled. So two important points in case of adjournment. Number one, if it is a meeting of requisitioners under section 100, quorum is not present, meeting is cancelled. Any other meeting, it shall be adjourned to the same time next week, same time and same place, or as the board may be decided. Yes, Kiran Mishra, very good. First, the articles should be checked. Then we have to follow the quorum for the act, as per the act. Very. Everyone is clear. So my question to all of you, the requisition is 1/10 of the shareholders requisitioned the board for the meeting, and within 21 days that meeting was to be called. Now board has called that meeting and the quorum is not present in half an hour of the time specified. Will the meeting stand adjourned to the next week? If it is one meeting called by the requisitionist, Komalpreet, good. The meeting stands cancelled. Same time. Khushbu and Kiran is saying, yes, ma'am, it's adjourned. Was I too fast or you did not understand what I'm saying? Meeting called by the requisitionists under section 100. If quorum is not present, what will happen to the meeting? It will be adjourned or it will be cancelled? Om Sagar, good. Yes, Kiran and Khushbu, it will be cancelled. Yes, now you have understood. Maybe I spoke so fast because they are running short of time. That's why you did not understand. Yes, it is cancelled. Good. Now, in case of the adjourned meeting or the change of date or time and place of the meeting, 3 days notice to the members individually or by publishing in the newspaper has to be given. So what is the time period for giving the notice for the adjourned meeting so that everyone come to know about the meeting at least 3 days in advance about the meeting? You have to inform that everyone has to be present. And now if the quorum is not present within half an hour, then what will happen? Please tell me. If now quorum is not present, so there were less than 1,000 members, 5 people have to be present, still 3 people have come in the adjourned meeting. What will happen? Please tell me, children. Then all the members who have come shall form the quorum for the meeting. So all the members who are present, if 3 have come, then 3 shall. Because in adjourned meeting, you can't just continue. Means you continue the meeting with the number of members present will form the quorum for the meeting. So out of 5, 3 are present. Now in adjourned meeting, you're not going to adjourn it further. 3 will be considered personally present. But if only one member is present, what will happen then? Can we count him as the quorum? Then present member form the quorum. Abhishek Singh, are you serious? One member will hold the meeting. I told you in the beginning that it is only section 97 and 98 which provide that tribunal when holding the meeting, even in one member person or in proxy is present to hold the meeting. Otherwise, one person cannot hold the quorum. At least 2 people have to be there because 2 people will be considered the quorum of the meeting. Then only you can convene the meeting. One person is never held the quorum unless, yes, absolutely correct. Good, Abhishek, present member from the com for previous question. Okay, right. So Swati is correct. No, ma'am, at least 2 people form the quorum. Okay. So for, okay, Abhishek saying I got your answer. For the adjourned meeting, if the quorum, whosoever are present will form the quorum. But if I ask you only one member is present, now answer me children. Will they form the quorum? No, ma'am. At least 2 members are required. Only exception is section 97, where tribunal is requesting for the AGM, and section 98, where tribunal is requesting for the EGM. So there are more little points which will take me a while to study about with you for quorum. So I think largely we have covered about the quorum, and 1 or 2 points about the body corporates I wanted to do with you, which I want to do with a detailed example. So it will take me a little longer. Any doubts still here? Because then time will not be left. Just hurry up and see the study material also. So we'll be starting with the left part of the quorum from the next class, and then we'll be continuing till section 122. And I request all of you, see how beautifully this ordinary business charts have been made. You will not find it in the previous study material, but this latest study material, everything has been updated and beautifully decorated for all of you. So that, yes, Rishabh Gupta, you'll get all these PDFs and notes on the portal as well. All the AGMs, EGMs, everything has been written over here. Quorum, this is what we are doing. So please adjourn meeting, all these points, you can refer to that presentation, small notes. And this one small question we can do. There are 54 members in Nice Games Private Limited. Company called its annual general meeting on 1st July at 2 p.m. at its registered office. There were 28 members personally present. So 54 members, less than 1,000. How many members have to be present? At least 5 will form the quorum. 28 members were present till 2:30 p.m. at the venue. Chairman of the company initiated the meetings and passed the resolutions after observing the due process. So they have not told you about the chairman meetings and everything, but they have given you a question relating to the quorum. Comment whether the meeting took place as per the provision. So here quorum for the private limited, children, please read it very carefully. I also said 5. Nice Games Private Limited, minimum number at least 2 shall be present. Within half an hour, 2 people are present for appointed for the holding the general meeting. Thus, the quorum is absolutely present. No contravention has been done. Even if it had been public company, then also the quorum is present or not. If it would have been a public company, then also it is a sufficient quorum, yes or not? 54 members हैं, 28 are personally present. Quorum is present or not? Yes. Plus 5 were personally to be present, 28 are, so it's absolutely fine. So this illustration number 7 also, please children, you can read it. It's very, very simple. So we'll be doing certain points and certain illustrations from quorum, and then we'll be proceeding to this further chapter. So well in time, 103 till 103 we have done. We'll be starting from the last part of section 103 and we'll be heading till 122. I hope no doubts. Thank you very much, children. I hope you enjoyed the session. And there are no doubts. And I hope we have been. Thank you so much, Om Krishnam. I'm glad you enjoyed the session. Thank you. Thank you, Abhishek, Yamin, Kiran. So I think we're done with the session. Students don't have any doubts. Even here, I can check it. Divya, Pooja, M. Goda. All right. All right. All right, students. Thank you so much. All right. We can end the session. Yes, it's